I want to take a moment and talk about a major law change that just took place in March of 2024. What you have to know is that in Florida, we have very lenient liquor liability laws that exclude bars and restaurants from being held liable, even when they're over-serving people who then get behind the wheel and drink and drive, causing injuries. There's only two exceptions that allow a bar or a restaurant to be held responsible for over-serving. The first is if a bar or restaurant willfully and unlawfully furnishes or sells alcohol to a minor child. So in March of 2024, the Florida Supreme Court had a case before it that had to do with these liquor liability laws. And what the court held was that even though the term willfully is used in the statute, this is not an intentional tort. This is a negligence action. And so what that means is that the doctrine of comparative negligence still applies to these liquor liability lawsuits. And what the doctrine of comparative negligence is you look at all the different parties involved and you compare their negligence against each other to determine whose fault the accident was. Why this is important is because the Supreme Court left open the question of whether you could use the comparative negligence doctrine to, for example, compare the negligence of a minor person who happened to be drunk as compared to the negligence of the bar. So it remains to be seen how these liquor liability laws and the doctrine of comparative negligence are going to evolve in Florida now that we know that comparative negligence of all the different parties can be used against them. If you or a loved one has been injured due to a drunk driver, please give us a call. We'd be happy to help.